Good afternoon. I am Deb Van Dyke Reese, and I'm the director of the Nebraska Court Improvement Project. And I would like to welcome you to the 2021 Legislative Overview. Prior to getting started, I want to go over some housekeeping items. We do have a large number of people that registered for this webinar. And so we are asking that only those that are going to be presenting have their cameras on. So if you would turn off your camera, that would be wonderful. Thank you. And also, because of the large number of people that are going to be attending this webinar, we're asking that you post your questions in the chat box, which is located at the bottom right-hand corner of your screen. Attorneys, if you would like to receive CLEs for this webinar, we ask that you put your name and your bar number in the chat so we can record your attendance with attorney services. Also, just so you are aware, this webinar is being recorded and will be available on the CIP YouTube channel later in the week. And then finally, Tracy from our team has posted in the chat a link for the spreadsheet of the bills that some of which are going to be discussed today, and then some that that we have been kind of watching. And so that that whole spreadsheet will be available on in the chat box. So next, I want to just thank all of our presenters, Judge Larry Gendler, Amy Bradner, Sarah Helvey, Taylor Gibbons-Dunn, and Mary Pat Coe for being willing to present and highlight some of the legislative bills for this session. So Tracy, can I have you move it to the next slide? I wanted to give everybody, for those of you who are not aware, an update about what CIP is. And so the Nebraska Court Improvement Project is a federally funded organization, and we are housed under the administrative offices of courts and probation. And so we facilitate our multidisciplinary network of judge-led teams known as Through the Eyes of the Child teams. And many of you, I'm sure, are members of the Through the Eyes of the Child teams, but the teams are guided by the resource guidelines and the enhanced resource guidelines that have been developed by the National Council on Juvenile and Family Court Judges. So each of our Through the Eyes teams selects its own projects and goals, and Judge Gendler is the project chair of the Through the Eyes of the Child initiative. But what we do is we support their work as they look to enhance and improve the juvenile court system in the state of Nebraska. So what I am going to do now is turn it over to Mary Pat Coe, who will start us off today with our webinar. Thank you.
Thanks, Deb. I'm just going to do just a quick rundown of how a bill becomes a law in Nebraska. We have a unicameral legislature, which means we just have the one house. We are unusual. I think we are the only state that has a unicameral system. The bills are introduced in the first 10 days of the session. All the bills get a fiscal note to estimate the state, county, and municipal cost of any changes. Each of the bills are then referenced to a committee, and every bill gets a public hearing where individuals can testify for, against, or neutral on a bill. Due to COVID right now, there have been some changes, so please look at the legislative homepage if you intend on testifying on any bills, and it goes through more details on that. After all the hearings, the committee can vote to send the bill to general file with or without amendments. They can indefinitely postpone a bill or just take no action. Once a bill gets to general file, if it does, it's the first time the full legislature has a chance to debate and vote on the bill and on any amendments that may have been filed. It takes 25 votes to adopt any amendments and to move the bill on from general file. Before it does go on from general file, it goes through enrollment and review. This incorporates any amendments that had been passed and checks for any grammar. If a bill does get to select file, this is a second round of debating and voting stage. It's another opportunity for senators to file any amendments to the bills that can be voted on, or again, a bill could get postponed. Again, if it goes forward, it will go to enrollment and review to incorporate any of those amendments and check for any grammar errors. If a bill does go forward to final reading, the bill is read aloud by the clerk unless this is waived by a vote of 30 senators. It may not be amended on final reading, but it could always get sent back to select file if there's a need. The bills need a majority vote to move on for the governor to sign. If a bill has an E clause, it'll need 33 votes to move on to the governor. Once bills do reach the governor, he has 5 days, excluding Sundays, to decide what to do with a bill. He can either sign it, line item veto, or veto the bill. There needs to be a vote of 30 to overcome a governor's veto. Once the governor signs it and it becomes law, it happens 3 months after the adjournment, unless there's an E clause with a specific date. There are priority bills. Each senator does get one, and each committee gets 2 priority bills, and the speaker can designate 25 priority bills. We are in the start of the long session, which is 90 days, and the last day projected right now is June 10th. So we're going to jump right into the bills. Judge Gendler, we'll start with the bills you are presenting today. Thank you.
Thanks everybody for joining us. If I don't get to a question, feel free to email me at lgendler@sarpi.com. One other thing I want to mention with the changes this year because of COVID, there's also an online form for every bill that you can fill out and submit if you're in favor, opposed, or neutral. The first one I'm going to talk about is LB 143, which is Senator Colderman's bill. There were efforts the last session as well. This has to do with notifying school superintendents of a change in schools. Last year's bill was rather lengthy, and I've got to credit Sarah Helvey, who's on this call, because she also assisted me with working on this latest revision that was introduced. And essentially what the bill does is when the department files a change of placement form, if they indicate it's in the child's educational best interest to change schools, a copy of that change of placement form goes to the sending school and the receiving school. So those folks know who to contact if they have any questions or concerns. The department came in with a fiscal note saying it would cost roughly $147,000 a year. We're not sure where that comes from. The Department of Education, we are told, has a directory of all the school districts with email addresses. So all the department would have to do is essentially email that form to the sending and receiving school district. That hearing was on the bill was heard last week. The next one I have on my list is LB 307. I was part of a conference call with Senator Pansing Brooks, Senator Kavanaugh, and 18 county judges. All of you are probably aware that this has been an issue that's important for all of us and for the senators, that being counsel being appointed for youth in the juvenile court system. The separate juvenile courts have that mandated. We've done that out of policy here since the juvenile court was established before my tenure. So Judge Turnbull has been working with the senator previously and expressed why rural senators are opposed to this bill, or the original bills, in part because a lot of cases that they see in their system we wouldn't see in ours. They don't have the diversion programs that we have, so they have a number of minor offenses that we would never see within our separate juvenile court system. So his proposal, which is adopted in this legislation, is that a county attorney can waive removal. And if the county attorney waives removal, then the child would not have to have a lawyer. But the county attorney can also vacate that waiver, and at that point, counsel is appointed for the child. One other provision that we got in there is the Supreme Court can establish a rule, because we all think it's important that youngsters be able to visit with an attorney privately before they go to court, since they have other issues that may be important to them that they need to discuss privately. Maybe they got somebody pregnant, maybe they're pregnant, being bullied at school, issues at home. So we just thought it was important that they be able to visit with an attorney, and that attorney may not necessarily have to enter an appearance in order for them to be able to consult with them. So that's essentially LB 307. The next one on my list is LB 568. This was a bill that was heard last Friday. It takes school truancy out of the juvenile code and attempts to provide more resources within the communities. Although school truancy is taken out of the code and it's now defined in the statutes as excessive absenteeism if this bill passes, a juvenile court can still order school attendance on any other case, be it law violation or other status offenses, and order consequences for their failure to comply. The hope here is that some more community resources can be made available, particularly at other jurisdictions in the rural parts of the state. Jeannie can talk about this when she is up for her sections of the bills, but she reported to us that probation would save roughly $3.5 million per year if this were taken out of the code. And the Department of Education is also supporting this endeavor as a way of trying to address these issues differently. As part of this, some of us have suggested that they reduce the age of when you can start on your GED, because right now it's 18. If youngsters could even start on that when they're 17 and a half, that would alleviate some of the concerns that several of us have with this proposal. The next one on my list is LB 330. This is Senator Wayne's bill that would extend juvenile court jurisdiction to 21. Originally in his draft that was circulated to several of us, it was 21 on all cases, but that was amended when he introduced the bill to age 21 on juvenile justice cases, not child welfare. My guess is this will probably be studied over the summer. There are some states that extend jurisdiction to 21. There are some questions as to what resources would or would not be available because of this change. And that committee, the Judiciary Committee heard that bill on January 28th. Then my last one in my notes, Sarah Helvey will also talk about this, is LB 262. Senator Vargas and Senator Pansing Brooks have introduced this. This would expand bridges to independence for those youth that are not here legally or don't have legal status. The vast majority of these youth that are in the system have a pathway to citizenship because federal legislation allows for them to becoming citizens if they were abused in their home country or abused in this country. So this bill would assure that they're eligible for bridges to independence services. One thing that's not included in this bill that would need to change, under Section 4-108 under our code, we are not allowed to spend any state money on anybody who's here illegally. So that portion of that statute would have to be changed. But I know all of us see these youth in the system on occasion who do well, but need additional supports before they reach the age of 21. So that's what I have on my list. And again, if folks have any questions, please feel free to email me if we don't get them to them today at lgendler@sarpi.com. Thank you.
Thanks, Judge Gendler. I think Sarah will have you present your bills now.
Okay, great. Hi, everyone. My name is Sarah Helvey, and I'm a staff attorney and the Child Welfare Director at Nebraska Appleseed. And I just want to thank the Court Improvement Project for the opportunity to present today. And I'm just going to mention a few bills that are priorities this session for Appleseed. The first are two bills that are, there are two bills this session related to the Bridge to Independence program, one of which Judge Gendler just mentioned. The first one that I'll say here is LB 202, and that was introduced by Senator Pansing Brooks. And the intent with LB 202 is to expand the Bridge to Independence program to include a subset of the juvenile justice population, specifically those youth who need the support of B2I because they would age out without a home to return to and may otherwise face homelessness. So the effort here was really to kind of try to strike a balance, to find a subset that could of juvenile justice youth, not to expand B2I to all juvenile justice youth who age out of the juvenile justice system, because we don't want to artificially keep youth on probation in order to make them eligible for B2I, but to try to identify those youth that again would otherwise be homeless or don't have a home to return to upon aging out. And so the way that LB 202 does that is requires the Office of Probation to identify potentially eligible youth, those who are in a court-ordered out-of-home placement 6 months before they turn 19, and provide those youth with information about the Bridge to Independence program. And then any party to the youth's juvenile court case can request a hearing during that 6-month time frame for the juvenile court to consider and make a determination whether it would be contrary to the youth's welfare to return to the family home, and if it's necessary for the youth to return in their out-of-home placement. And then LB 202 sets forth factors for the juvenile court to consider in making that contrary to the welfare determination. That includes that the youth is at risk of homelessness at the closure of their juvenile court case, that the youth is disconnected from family support that would assist them in transitioning to adulthood, and that the Office of Probation has made reasonable efforts to return the youth to their family home prior to the youth's 19th birthday. Then LB 202 provides that if the juvenile court makes that necessary finding, and therefore the youth is potentially eligible for B2I, then the Office of Probation is required to notify HHS within 10 days. HHS is then required to provide information to the youth about B2I as soon as practicable and prior to their 19th birthday, so the youth can decide if they want to participate in B2I. The program, as I think most folks know, is voluntary, and that would continue with this new population. Youth with juvenile justice cases have to meet all of the other eligibility requirements for the B2I program, including participating in a work or education activity unless they have a medical condition or barrier to education and work, and meeting the Nebraska residency requirement. And then once in the program, the benefits and responsibilities are the same, including monthly visits with their caseworker or independence coordinator and the court hearings. And this bill, along with the next bill on B2I, both have a hearing in front of the HHS committee on Thursday of this week, on February 11th. The second one that is LB 262 that Judge Gendler mentioned was introduced by Senator Vargas, and that is to make clear that young people are eligible for the Bridge to Independence program regardless of their immigration status. This includes young people who are not lawfully present in the United States, and would mean that the department, they have a regulation that denies youth application for B2I based on lack of immigration status. But would, as with the prior case, require those young people to meet all of the other eligibility requirements for the Bridge to Independence program. And LB 202 would also clarify that those youth are eligible for all of the services and support as part of B2I, including medical coverage, and specifically directs the department to submit a Medicaid state plan amendment for approval to provide that medical coverage to all youth in B2I, again, regardless of immigration status. A little bit of background on this bill: Appleseed litigated a couple of cases on this issue with our partners of the Immigrant Legal Center up to the Nebraska Supreme Court, and we lost. One of our primary arguments was that B2I is extended foster care, and we don't exclude this youth in the under 19 foster care case based on immigration status, and that this population was intended to be included in the B2I program. But the Supreme Court essentially said that because of LB 403, that's the statute that Judge Gendler mentioned, that excludes immigrant eligibility for certain public benefits, if the legislature wanted to include that population, they needed to have an affirmative inclusion and be really specific. And so that is what LB 202 seeks to do. And again, that has a hearing this week on Thursday. The last bill I wanted to mention is LB 357, known as the Youth and Care Bill of Rights, that was introduced by Senator Megan Hunt as a follow-up to an interim study she had in 2019 and a similar bill she had last year. As part of that interim study, there were focus groups with over 50 youth across the state to get their input on the existing but more limited notice of rights that's required to be provided under the Strengthening Families Act to youth in care at age 14 or older. As part of that process of hearing from youth, we heard that those youth are not receiving that notice and that they didn't know what recourse they have when they feel their rights have been violated. And so LB 357 includes that youth input and is a more comprehensive list of rights for youth in care. The biggest change from last year's bill is that LB 357 only applies to youth in foster care and YRTCs. It does not apply to youth with JJ cases supervised by probation because of concerns about parental rights, which are still intact in those cases. And then like last year's bill, just to note, not only does the bill include a more detailed list of youth rights, it also clarifies the roles of those who can provide support if youth feel their rights have been violated, requires caseworkers to be trained to discuss it and provide a copy upon their removal quarterly at meetings and at court hearings. It also requires GALs to discuss the rights with the youth regularly and raise infringement of those rights in court as appropriate. And then it also strengthens the grievance process and youth's notice of or understanding of the grievance process if they feel their rights have been violated. That bill had a hearing in front of the Judiciary Committee on January 28th, and there was no fiscal note. So we're hoping that that one can move forward this year. I wanted just quickly to mention a couple things on LB 143. That's the educational placement bill that Judge Gendler mentioned that did have a hearing last week. There was a fiscal note attached to that, but I believe that there was an amendment put in to clarify that it's notice only that the department has to provide to schools, not also the educational records, because those are already provided to be shared under federal law as appropriate. And I think with that clarification, that it's hopeful that that will address the fiscal note. There was also discussion at the hearing by some school officials were interpreting the bill and I just mentioned this because I think we have some education folks on the call, to include a right to appeal a placement decision if there are concerns about the best interest of the child with regard to that. I read the bill to say that it says that interested parties may file an objection, and the court may have, if any interested party has a concern about placement, and an interested party, I would agree, includes schools with the notice in there and in the bill, and then the juvenile court may hold a hearing with regard to that. So I think we're kind of both right. I wouldn't characterize it exactly as the right to appeal, but it does have that process within LB 143 for the court to hear those concerns and objections of school districts. And with that, I'll turn it over to the next presenter.
Thanks, Sarah. Before we get to Taylor, I just wanted to make a mention on the descriptions you're reading in there. Those are my descriptions, so I don't want anyone to think that the presenters made any mistakes you may see. You can attribute those all to me. And also sometimes you'll get my 2 cents in there as well. So again, those are my comments, not necessarily the presenter. With that, Taylor, you are up.
Great, thank you. Good afternoon, everyone. My name is Taylor Givens-Dunn, and I'm the Policy Coordinator for Child Welfare and Juvenile Justice at Voices for Children. There are a couple of really important juvenile justice bills that Voices for Children is working on and has prioritized this session, so I'm hoping to run a couple of those by you. On this first side, we do see LB 307, which Judge Gendler beautifully talked about, so I won't rehash that. The part of this bill that is really important to us here at Voices is the Supreme Court rule to ensure that youth are getting that face-to-face time to consult with an attorney as they're making a decision to waive. And we'll see the same with LB 262 and 202. Sarah beautifully described those two B2I bills. Both of those are bills that specifically the juvenile justice expansion is a bill that Voices an issue that Voices has worked on for several years, and we're hoping that this is the year that we'll see that change go to kind of protect and wrap our arms around that vulnerable population. So the next two bills that I want to talk about are LB 537 and LB 445. LB 537 is a Senator Geist bill. It had a hearing last Friday, and it walks back some of the reform that we've seen made to the juvenile justice system over the past couple of years. So several years ago, in 2018, I believe Senator Vargas had a bill, LB 1112, and in the language of some of that statute, it prevented youth under the age of 12 from being detained. LB 537 allows youth under 12 to be detained if they are harmed not only to themselves but to others, but to themselves as well. This is something that's really incredibly concerning to us because 12-year-olds that are at harm to themselves, we know that detention is not the best place for them. LB 537 also allows youth 14-year-olds to be placed at YRTC if there's a risk to themselves or others. This is incredibly concerning for a host of reasons. We have had the opportunity to talk to Senator Geist, and we know that this bill is born out of a concern for what to do with youth when they are, I think the language he used was out of control. This bill had strong law enforcement support, but I think as we, as advocates, think about what 537 means, I think we have to really consider how we are supporting our youngest people in the juvenile justice system. LB 445 is a Senator Matt Hansen bill that adds protections for a young person who is undergoing interrogation. So LB 445 provides that if a young person who is being interrogated asks for a parent, that this acts as a Miranda right protection so that they are able to talk to a parent or guardian prior to the interrogation continuing. This also includes provisions for notifying a parent, guardian, or custodian for that youth that the youth is being interrogated as well. And then it also provides that if a young person asks for a parent or guardian or custodian, that any interrogation that continues further after that will be deemed inadmissible. So it goes a long way in ensuring that youth who may be scared, who are, again, just youth, have access to not only counsel, but have access to a trusted adult as they go through that interrogation process. So with that, I will turn it over to the next presenter.
Thank you, Taylor. Jeannie, if you can present your bills.
All right, good afternoon. Thank you. My name is Jeannie Bradner, and I'm the Deputy Administrator overseeing Juvenile Services for the Administrative Office of the Courts and Probation. Thank you to CIP for hosting this webinar today, and thank you to all of the co-presenters who have presented on many other bills. My three bills that I would like to discuss with you are displayed here currently. All three of these bills have already had their hearing. The first one is LB 494. Senator Hilkeman, this is an increase to foster care rates. This was born out of the Nebraska Children's Commission under the Foster Care Rate Reimbursement Committee, and so it takes recommendations specifically from the Foster Care Rate Reimbursement Committee's report and puts them into this legislative bill, LB 494. Was heard on January 29th at the Health and Human Services Committee, and for the record, I do know that HHS did oppose the bill in terms of that this fiscal piece is not in the governor's budget. Very similarly, the next one is LB 541, Senator Walls. This also came out of that same process, the Nebraska Children's Commission and the Foster Care Rate Reimbursement Committee. This particular bill looks at the addition of 2 formal levels of foster care, one of which is a specialized service, which probation is utilizing a similar strategy. We call ours professional foster care. So essentially it's a higher level foster care service. And then the second part of this is a treatment family care model. This is a Medicaid reimbursable service. So again, Pat, thank you for acknowledging the questions in here. I was wondering where those came from. But that definition is a Medicaid reimbursable service, and it is different from the enhanced family home that is a developmental disability type service. So that, again, was heard also on the 29th in Health and Human Services Committee, and similar to above, Health and Human Services did oppose this because the fiscal additions that were not outlined in the governor's budget or the agency's budget. The last one I have for you today is LB 638. This one comes out of the Health and Human Services Committee and the special oversight that has happened on the YRTC facilities. This report does require an addition to a report that already exists for us. Our state court administrator is required to produce an annual publication regarding specific juvenile justice information and data. So this particular bill, LB 638, asks us to separate those youth that have been committed to the YRTC and look at their recidivism rates distinct and separate, as well as the number of those youth that complete probation, the number of motions to revoke and actual revocations, and then what services each of those youth are accessing that are provided through our state allocated funds. That's what Program 437 is. Again, this bill was heard last week on the 5th in the Judiciary Committee. And there was also some testimony at that same time by Inspector General Jennifer Carter that asked for some additions to that report. We are continuing to work with Health and Human Services Chair, Senator Arch, as well as Inspector General Jennifer Carter to work through those additional requests and extra language. So more to come on that. That's all I have. Thank you.
Thank you, Jeannie, and thanks for answering the questions I had. I am Mary Pat Coe. I'm a project specialist at the Court Improvement Project, and I also have a few bills I wanted to discuss. The first one is LB 89 by Senator Moorfield. This bill would allow 18-year-olds to make healthcare decisions. It would also allow anyone under 19 who is committed to the Department of Corrections to consent to mental health, medical care, and other related services. Senator Moorfield had a similar bill last year that ended up being amended into a bill affecting parole eligibility. That bill passed, but it ended up getting vetoed by the governor. I believe the fiscal note may have been too large at the time when we were dealing with COVID. This bill not only is going to help college kids get medical care, but it's going to be a great help for our homeless youth population out there. My personal wish is that the age was 17. The next bill I want to discuss is LB 201 by Senator Pansing Brooks. This bill would give original jurisdiction to juvenile court. Certain cases could then be transferred by filing a motion to county or district court. For instance, if an offense falls under Section 1 of 43-247 and the accused was 16 or 17 years of age when the alleged offense was committed, or if an offense falls under Section 2 of 43-247 and the accused was between 14 and 17 years of age when the alleged offense was committed. Senator Pansing Brooks had introduced a similar bill to this in 2019. The next bill, LB 273, introduced by Senator Lowe. This bill allows DHHS to move youth around the YRTC system, and also any facility operated and utilized as a YRTC in compliance with state law. It seems as if this bill, the DHHS can move a youth around within the YRTC system and these new designated facilities, and this could happen without court involvement. At the public hearing last week, several senators on the Judiciary Committee commented that they felt this would unwind everything that LB 1148 put in place last year. So I think this is going to be a highly contentious bill, and we can keep you updated on that. LB 354, introduced by Senator Lathrop. This would require the county and district court judges to issue a decision on a motion to transfer jurisdiction of a minor to juvenile court within 30 days of that hearing on the motion. Right now, juvenile court judges already have to render a decision in 30 days on a motion to transfer. So this would just even the playing field across. So all judges would have that 30 days. I think the hope on this is that kiddos won't be sitting, waiting for waiting for decisions for judges on are they going to juvenile court or not. The last bill I wanted to discuss was LB 492 by Senator Michaela Cavanaugh. This bill would create the Nebraska Integrated Juvenile Data Governing Body. The purpose of this is to create a unified juvenile justice and child welfare data system, which would be managed by the Juvenile Justice Institute at UNO. The bill sets out positions to be on the governing body, and it also describes various data to be integrated, such as NDE data, HHS, probation, detention centers, court systems, law enforcement, and county attorney offices, to name a few. The bill also sets out purposes and safeguards to be addressed in the plan for the integrated system. That is the last one I was going to discuss. Is there any questions that any of the participants have out there, or and Jeannie has a follow-up. Excellent, Jeannie.
Thanks, Mary Pat. I did not mean to ignore Judge Gendler. So Judge Gendler, I had a note written down here and I totally forgot after I reviewed my bills, but I just wanted to go back to your comment that you had mentioned on LB 568, which is Senator Pansy Brooks' excessive absenteeism bill. And yes, I can confirm that the information that Judge spoke about is accurate. We went back and reviewed fiscal year 18, 19, and 20. And over the course of those 3 years, the dollars that are being spent on truancy-only youth have ranged, they've gotten greater each year, but 2.7, 3 million, and then ultimately in fiscal year 20, 3.5 million. A large portion of that is due to out-of-home placement. Out-of-home placement is obviously your most expensive service. So of that 3.5, 2.1 is out-of-home placement and 1.4 is in-home and community-based services. So while that wouldn't necessarily be a cost savings, it would be a cost shift. The way I understand it is those dollars would then be available either through community-based aid funding or to the schools or some other avenue, because we do know that excessive absenteeism cases do need services, do need support. And so if probation no longer supervise that population, those dollars would be available to allocate elsewhere. So thank you.
Thank you, Jeannie. Does anybody in our participants have any questions for any of the presenters, or maybe even questions on a different bill that they know has been introduced? And I mean, this is your chance to ask some people who are following these bills and, in my opinion, are experts on juvenile justice and child welfare. Or any of my presenters, is there anything they wanted to touch on?
Jeannie, could you clarify, first bill you talked about, I think you referenced LB 494, but on the printout it says 495. So is it 494 or 495?
The foster care rates is, I believe, 494, but I will double check that.
I see in the chat somebody asked about the marijuana bills being tracked. Yes, They are, let's see. I don't know that they have been set for hearing yet. Oh, I take that back. LB 481 is set on the 19th at 1:30 in front of Judiciary. And I believe the other marijuana bill is also set at the same time in front of Judiciary. Yes, LB 546 by Senator Wayne. So yes, we are checking those. I think I may have missed one of the questions. Okay, thank you. I think somebody answered the LB 89.
I can jump in. There was a question about how many potentially could be served by LB 202. LB 202 is the Juvenile Justice addition to B2I, and I might pass it over to Jeannie for an estimate of that. They also asked on LB 262, I think the question is also from Chris, if we know the numbers on that. We'll see what the department estimates, or if they're able to do that as part of the fiscal note. I don't know that there's good data on the immigrant population within child welfare, so I don't think going into that I have a good idea of the numbers for the immigration bill, but I'll pass it over to Jeannie for the juvenile justice population of those who are in out-of-home placement 6 months prior to their 19th birthday.
Thanks, Sarah. It's really hard to get at this data. So we looked at a number of pieces. We looked at the age of youth when they do discharge from probation. And then we looked at the 19-year-olds that left probation that were in placement, I think, within the 2 weeks prior to their 19th birthday. And so that would suggest to us that there was likely a reason that they remained in placement and that they probably didn't have elsewhere to go. So not knowing, again, with the possibility of bridge being available, if those numbers will be higher or lower or about the same. So we did go back about 4 years. We looked at 18, 19, 20, and 21. And so the number of youth are around 32 each year, no higher than 32 over the course of those years that have remained in out-of-home placement. And also, I just wanted to note here that out-of-home placement can mean a number of things. That can mean treatment, that could mean detention, that could mean YRTC, that could mean group homes, foster care, all sorts of things. So those are kind of the guesstimates that we're looking at. And again, not all youth who remain in out-of-home placement would be eligible, as Sarah Helvey spoke to. So there would have to be a hearing and findings to present information that it would be contrary to the youth's welfare for them to return home, whether they aren't supported or may run away or other situations. So it's really hard to tell what those hearings would find, but that is our best guesstimate for eligible participation.
Thank you, Jeannie. Okay. I think any other questions from any participants? Any of my, let's see. I think Judge Gendler put something in the chat. There are two bills related to foster payments. LB 495 addresses foster care rates generally. LB 541 addresses foster care rates with a focus on Tier 4 foster parents, which is a specialized foster care. Thank you for that. Any other comments or questions? Because I know somebody asked what the stance is on the marijuana bill. I think we're all just going to be neutral on that, and we'll just see what happens in our Nebraska legislature on that. I will tell you that I do my best to keep this spreadsheet updated to when hearings are, as bills move into general file, or whether they get indefinitely postponed, whether amendments are filed, and I'm certainly happy to share that at any time during this session. If you want to email me, I'm happy to send it, whatever state it is in, send it along to you. I think from Laura, if you have questions about LB 541 or LB 495, please feel free to reach out to her. Laura, I'm going to spell your last name, Laura, larura.opfer@nebraska.gov. Laura, can you put in the chat where what agency you're from? And while she is from Nebraska Children's Commission.
Mary Pat, this is Deb, and I just wanted to point out that Sandra Markley had a question about LB 202 that was in the chat. I don't know if Sarah or Mary Pat, you want to discuss that? It says, wouldn't it be better to file a 3A on probation youth who could not return home due to no fault of their own? Any comments there?
I'll just say the reality is that doesn't happen very often in those last few months before youth turns 19. And oftentimes those populations look very similar. And so we think that the bill as it is strikes a good balance between the concerns that you noted about the various rewards and incentives and disincentives. But I'd invite Jeannie to comment if she'd like to as well, or Taylor.
This is Jeannie. I absolutely will add to that. And just to clarify that filing a 3A ends at 18. So that gap year of 18 to 19 is not possible for those filings to occur. And there is also some reluctancy across the state with older youth and 3A filings. And so, again, it's not a common occurrence that we are seeing youth in the juvenile justice system that need some additional support as they age out, but it certainly is something that we have seen. And so, as Sarah Helvey mentioned, the bill does look at the balance for those that have some support issues that remain and those who can move on and feel supported in their communities and their families and their lives when they do age out from juvenile justice involvement.
Thank you, Sarah and Jeannie, for handling that. Marcy Berkowitz had also put in the chat, reiterating what Jeannie had said, that you can't file a 3 on an 18-year-old. Any other comments or questions from any of the participants or any of the presenters? Not, I just want to extend my thanks to all my presenters for being here, giving their time to me. I greatly appreciate having all their expert knowledge on this webinar. I certainly couldn't do it without them. Again, as I said before, if anybody is interested in the spreadsheet at any time while the legislature is in session, just email me and I'm happy to send it on. Thank you all for attending. We appreciate you, and we will have a follow-up webinar at the end of the session, probably later in June, and we will send out a mass blast for that. Thanks again.